You are using the device audio. Okay.
Hi, everyone. Thanks for joining the call. We'll be starting in just a minute. I see a few people still connecting to audio.
Recording in progress.
Good to see you, Ed.
Hi, John.
All right, well, let's go ahead and get started. Good afternoon, and thank you for joining our call. My name is Bernadette Tacey, and I'm with Alliance Defending Freedom. Alliance Defending Freedom is one of the nation's most respected and successful Supreme Court advocates with 13 victories at the U.S. Supreme Court since 2011. In just a minute, we'll hear from John Bursch, ADF Senior Counsel and the Vice President for Appellate Advocacy here at Alliance Defending Freedom. As we continue with the call, please keep yourself muted. There will be a portion dedicated to Q&A, so feel free to unmute when that portion comes up. But first, we will be hearing from John Bursch.
Good afternoon, everybody, and thank you for being here. This opinion that Judge Fleischer issued today is extraordinary for multiple reasons. First, lawsuits require adverse parties. What that means is you have one party advocating an issue and someone else who is opposing them. But we don't have that here because the defendant, the Michigan Attorney General, agreed with the plaintiffs. That means there is no adversity, contrary to her oath to uphold and defend Michigan law. As a result of that, not only Right to Life of Michigan and the Michigan Catholic Conference, but the Attorney General herself all agreed that this case had to be dismissed. Instead, the judge did not dismiss the case and issued an injunction. That is extraordinary. Second, the Michigan Court of Appeals has already held that this exact same 1931 pro-life law is valid under Michigan's Constitution in a case where Planned Parenthood sued and lost when represented by the very judge who issued today's opinion. That too is extraordinary. Even more extraordinary, the same judge makes annual contributions to Planned Parenthood, in effect, indirectly subsidizing the very litigation which she is now deciding, and has also received an award for a Planned Parent advocate. She should have recused herself from this case and not participated in it at all. That too is extraordinary. Finally, on the merits, the judge engaged in an analysis without any advocacy from the other side, and she was demonstrably wrong in her legal conclusions, drawing on precedents which have absolutely no bearing on pro-life laws, and then issuing a really broad injunction that purports to bind not only the Attorney General, but other people in the state of Michigan who weren't even parties to this case. That too is extraordinary. For all these reasons and many more, Right to Life of Michigan and the Michigan Catholic Conference are carefully considering what options they can take to pursue next, but something will be pursued.
All right, thank you so much, John. Again, feel free to unmute yourselves if you have a question. We are entering the Q&A portion of the call. And if you do not, please keep yourself muted.
John, can you address whether Right to Life or the Michigan Catholic Conference can't have any role going forward? You're not formal parties to this case. You were allowed to file, I think, amicus briefs. I mean, who can appeal this? Republican lawmakers or the legislature? Can you explain that if you want to appeal?
Well, yeah, the Attorney General has already declared that she will not appeal this ruling because, again, she agrees with it. That's why the case should have been dismissed. We have intervened on behalf of Right to Life of Michigan and the Michigan Catholic Conference in 2 other proceedings arising out of the same lawsuit that Governor Whitmer filed, one in Oakland County Circuit Court and one in the Michigan Supreme Court. And intervention is appropriate because these organizations have long advocated for pro-life laws in Michigan, have successfully lobbied for them in the legislature and helped pursue ballot initiatives. And for those reasons, Right to Life of Michigan has been recognized as an intervener in other pro-life litigation. So it would be appropriate to do that here. We have not yet intervened in this Court of Claims litigation because that creates the exact adversity of parties that is necessary for jurisdiction. And so we're reluctant to do that. But there are other ways that you can pursue appellate review without necessarily intervening as a party.
Right, and Paul?
Hi, John. So what happens, let's say this judge denies a request to intervene, then am I wrong in thinking there's really no appeal of this ruling? And what would your other options then be? You could file some kind of separate action. What do you do if you can't intervene?
Yeah, there are all kinds of other remedies that you could take to the Court of Appeals, including, writs of mandamus, superintending control, things like that, that would allow a court to essentially take a case away from a judge who should not be issuing any decisions because of an ethical conflict and also because she lacks any jurisdiction over the case. So those are some of the options. In addition, a government entity could intervene in the Court of Claims, like the Michigan legislature could step in and do that. They haven't so far, presumably because that would create the very jurisdiction adverse parties that this case currently lacks. But at a minimum, if the Court of Appeals won't intervene now, something we could consider is intervening as a plaintiff in this action and asking for a declaratory judgment that the law that the judge just enjoined is constitutional under Michigan's Constitution, or if it isn't, that federal law supersedes any ruling like that, and that too would give us appeal rights. So there are a variety of ways that we could pursue a Court of Appeals review of what is an extraordinary, unprecedented decision.
All right, thank you. And Beth?
Hey, thank you for taking questions. A couple of quick ones. Right to Life of Michigan and the Michigan Catholic Conference, I mean, technically they don't have standing to intervene as a defendant in this, correct? Because you have to be a statewide actor to intervene in a case in the Court of Claims. So I guess that's
correct.
And then my other question is, do you consider this decision binding on prosecutors in the state? Because I know there was mention at the bottom of the order about Nessel kind of having to tell people under her supervision, but Nessel has earlier said she doesn't think she has the authority to tell prosecutors not to enforce this. So I was just hoping to get your take on those.
Yeah, let me just elaborate on that first question, and then I'm happy to answer the second one as well. We can intervene in the Michigan Supreme Court and the Oakland County Circuit Court because there are no restrictions on party intervention in those courts. As you mentioned, we could not intervene as a defendant in the Court of Claims because only government entities can be defendants in the Court of Claims, but we could intervene possibly as a plaintiff because we have the same interest in upholding the law that Planned Parenthood is claiming in trying to strike down the law. So that would be a path to intervene, but that's something that we're still considering. With respect to the county prosecutors, I think the Attorney General was absolutely right that while she has some supervision of county prosecutors, she does not have the right to control them. So to the extent that this opinion purports to apply to them, I think it's invalid. That was the Planned Parenthood request, and it's not clear from the language that Judge Fleischer used. But since the Attorney General can't control county prosecutors, they get to make their own independent charging decisions. This order cannot bind them.
All right, thank you. And Ms. McDonald?
Hey, John, two questions. Can you give us a timeline for when you anticipate making any determination on legal steps? And number two, am I correct in what I heard? You called this, is it correct that your quote is this is a rogue judge?
Well, it's certainly a rogue decision. And if I said judge, I apologize for that, because I have a great relationship with Judge Gleischer and I do respect her. But it's a rogue decision for someone who is ethically conflicted out of hearing a case and who lacks jurisdiction to decide the case to nonetheless go ahead and issue an injunction against the Attorney General of the state based on merits arguments that no one has opposed or argued in front of her in briefing or in oral argument. In fact, she had originally promised to schedule an oral argument on the preliminary injunction request. And then when she convened a scheduling conference to discuss that and apparently decided that she wasn't going to do that, she had invited us to participate. But when we called in, she told us that we weren't allowed to participate because we weren't a party. So this was all done in secret with parties who all agreed on the result. It's improper 6 ways from Sunday. Now, your first question, what was that again?
Sorry, just had to unmute myself. Timeline on a decision on what sort of legal maneuvers you guys are going to take. And is it fair to say you are going to take legal action?
We are unquestionably going to take legal action, and I would expect that decision to be announced by the end of the week.
Thanks.
John, do you see this ruling having any impact on Governor Whitmer's lawsuit where she's asking the Michigan Supreme Court to make a ruling?
Well, it really shouldn't, because at least in that case, you have defendants who are defending the case. There are 2 county prosecutors who have indicated an intent to defend. So in that case, there's actually jurisdiction to proceed if there was a live controversy, which of course there's not, because Roe versus Wade is still the law of the land. Whereas here, there's no jurisdiction whatsoever. So I would expect that within a very short time, the Court of Appeals will vacate this decision and it will have no impact on that other lawsuit. I would add to that what Attorney General Nessel said correctly is that Judge Gleischer should dismiss this lawsuit and direct the Planned Parenthood plaintiff to participate in Governor Whitmer's lawsuit. That would be an appropriate place for them to bring any claim that they might have.
Thank you.
Hey, John, just to quickly clarify on this, that you mentioned earlier that you guys are not, that Right to Life in Michigan and Michigan Catholic Conference are not interveners per se, but they are amici, right? Is that their official standing in the case?
That's correct.
All right, I don't see any more hands raised, but are there any additional questions for John?
Yeah, actually, I do have a follow-up. You know, we've heard consistently from the legislature that they're kind of reviewing their options at this point. Are you guys encouraging them at all to intervene in this as defendants, or do you feel like they should stay out so there's not an adverse party?
Well, presumably they've been staying out to date, correctly in our opinion, because that could create adversity. And if there's no adversity, then the court lacks jurisdiction and should not proceed. I know they're going to be looking at their options now that Judge Gleischer has ignored the threshold requirements for moving ahead with this lawsuit. But they may wait to see what the Court of Appeals does with this as well. Keep in mind that this is a preliminary ruling. It's not a final judgment. In the long run, it doesn't, or short run, it doesn't really have any impact on anything because Roe versus Wade is still the law of the land. So there's no emergency for anybody to rush and do anything other than to stop a court from proceeding where it lacks jurisdiction. You know, and I'll add to all of that that this is the kind of mess that you end up in the court system when the state chief executive and its attorney general refuse to uphold and defend the law that has been in place since 1931. You know, they may not like it, but no one has the ability to unilaterally ignore, change, encourage the invalidation of Michigan law. They should be working through the democratic process just like anyone else.
All right, and we do have a question in the chat that I'll go ahead and read aloud. This is from Lisa. It says the suit challenged 750-14 only, and the judge specifically noted that other abortion regulations remain in effect. Does this mean that portions of the 1931 law still stand, or does her opinion enjoin the full statute?
The way I read the four corners of the opinion, and it only applies to 7050.14 and nothing else. Those were her words. So I think we have to take them at face value.
All right, are there any other questions for John? Okay, well, thank you all. If you have any additional questions, please reach out to media@adflegal.org. Again, that's media@adflegal.org, and we'll be able to provide you with resources, past press releases, quotes, bios, and any other resources that you might need. Thank you all for joining the call.